Hello, good morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with labor attorney Jung Bong-soo, we will discuss about the Labor Standard Act, Article 53, which is the restriction on extended work. So, could you define about the terminology of this Article 53, please?
Okay. Hello. How are you today? This is Bong-soo Jung, Korean labor attorney. So Article 53 of the Labor Standard Act stipulates that weekly working hour cannot exceed 12 hours in addition to 40 hours. So that means the 52 hours are maximum working hours the employee can work. So if employer introduce the flexible working hours, so in that case they can add 12 hours more based on the total like maximum working hours. Then they can work up to 52 hours plus 12 hours, then it can be 64 working hours. So this article regulates weekly maximum working hours. So the Article 50 regulates the weekly and daily the legal standard working hours, like 40 hours per week, also 8 hours per day. So based on the 40 hours per week, employee can work up to additional 12 hours. It can be 52 hours. So this article explains Korean maximum working hours per week is 52 hours. So here, what is meaning of 1 week? 1 week means 7 days excluding the weekly holiday or holidays. So including holidays. So in total 7 days. This definition is very clear. So we used to be very confused with this definition. How many days are 1 week? So Labor Ministry explained 5 days, but court explained 7 days. So finally, lawmakers introduced 1 week means 7 days. So legal standard working hours per week is 40 hours. So based on 40 hours, overtime can be allowed up to the 12 hours. That means 52 working hours. So that is the maximum working hours. Yeah.
I see. Previously, we have talked about Article 51 and 52, which is a flexible working hours system and selective working hours system. So this Article 53 is in addition to those two articles. There's a restriction on extended work. So I think it's very important for both employer and employee to understand exactly about this article, maybe 3 articles, in order to avoid any conflict. So do you remember any case where there was some dispute between the employer and employee?
Yeah, I think Article 53 deal with the criminal charge for violating the maximum of weekly working hours. So usually workers' perspective, they only claim whether company paid overtime allowance or not, those hours exceeding some 40 hours per week or 8 hours per day. So this article, it provides maximum working hours like 52 hours. It doesn't deal with daily maximum. So it only deals with weekly maximum working hours in Korea. So 52 hours, like 52 hours means overtime 12 hours, and legal standard working hours per week is the 40 hours, then in total 52 hours. So last month, December, Supreme Court ruled that there are no limit for daily, but there are a limit for working, for extended work. That is the 12 hours. That means legal standard working hours per week is 40, then overtime is 12, then 52 hours are allowed. So one company they have some long time work, intensive time, like 12 hours per day. So they work 40 hours and take 3 days off. So they each day they work the overtime for 4 hours additionally, like 8 hours plus 4 hours. So they work the 12 hours 4 days straightly. So in this case, overtime will be 16 hours. So okay, so it is more than 12 hours. So workers claimed and sued the employer for violation, but Supreme Court ruled that is not violation because total maximum is 52 hours, not 48 hours. So they dropped the case, withdraw the case because they focus on maximum weekly working hours when they judge whether company violate labor law or not for this extended working hours. Yeah.
I see. From the employee's point of view, unless they quit the job, I think it will be very difficult to sue the employer because of the, in case of Korea, like cultural issue.
Yeah, that's right. Yeah, I agree. But nowadays the employee get all information very easily from the internet searches, so they can find some information, and we can see many cases while they work at the same time they claim to the labor office for loss paid overtime. So I think workers they feel very confident because there are many free legal service provider like labor attorneys. So they become very confident even during the employment. They take legal action to get back the loss paid salary. Yeah.
I see. Thank you very much for your comment.
Okay, thank you for watching. Bye bye.